turn of events today. A couple of things have happened in regards to the Lively Wayfarer case. And that is that the case has been delayed. Instead of being held in March of 2026, it's potentially going to happen in May of 2026. The other thing that happened is that the judge released a referral today for the case to be referred to a magistrate for potential settlement. Now, there's a few things, and remember, I'm not an attorney, I'm not legally experienced, etc. These are just my thoughts and opinions when it comes to cases based off of the things that I know personally, mostly from local criminal cases. In my thoughts, I don't think that this is out of the ordinary. To my knowledge and understanding, this is procedural, it does happen. And one of the reasons why I think it is happening is because judges will often push these for referral to potential settlement because when a case has lopsided evidence, among many other things. But I think that is one of the primary issues that might be urging this for referral, because there is a laundry list of other things that are happening with this case that would make it more procedural and more usual for this type of thing to be sent to a magistrate for potential settlement. Now, the other reason why on my own thoughts and beliefs in regards to this case, with that laundry list of things that have been built up with this, I think this dual situation happening today is kind of the court's way of indirectly putting pressure on the case to go to settlement as opposed to going into trial. One of those things, the reason why I believe that is because when you have a case that I feel is built on a graham cracker crumb foundation and could crumble at any moment, when you delay a case, there's a financial involvement, and there's also, even the mental load. So it is likely that if there were a person that doesn't have the financial ability to sustain a delay and also doesn't have the mental wherewithal to continue waiting for this case to go to trial, that could be a way that the court is indirectly, without saying like, hey, this just shouldn't go to trial. It could be one way that the court puts pressure on a party to make a decision in regards to whether they want to stay the course or if they want to take an out prior to that. So that's just my thoughts, because here's the thing with Judge Lyman specifically. He sees what's redacted. He sees more than we do. He sees the depositions. He's been there for the things that we do not have the ability to know about. And in my opinion, there's likely a lot of things that the judge has seen and has privy of, and we don't have access to. And in that regard, he could know enough to realize this case shouldn't go to trial. It doesn't have the foundational pieces that you would expect by this point for a case to this level and this degree, and also for the claims that are being made. So it is possible that it's not just procedural and that it's the judge recognizing timeout. There's not enough to get us to the finish line. So, it could be a multi-layer way of putting pressure on a party. And I'm not saying that this is specifically about Judge Lyman putting pressure on Lively. I'm just saying that in my opinion, based off of what I see and what has been coming out in the dockets, that this is a possibility. So between the referral for potential settlement and the delay, it shouldn't be too much of a upset in terms of nobody saw this coming. In my opinion, from what I know with civil cases, this is just a procedural situation. And I do believe that with civil cases, the potential for settlement is constantly, consistently on the table. So it shouldn't be a signal that things are worthy of fireworks if a judge or anything is being said or stated about settlement. Because from From what I know of civil cases, settlement is often spoken of immediately out of the gates, and almost with every time a new docket is released, every time a new motion is allowed or denied, there is usually the revisit of, the question of settlement. So I don't think this is one of those moments that anybody should be like, "Oh my gosh, it's being suggested to go to settlement." It's typical, in my opinion. So, and who knows? Maybe the lawyers are gonna come out and give their information, and by the end of the day, I'm gonna be eating crow, and I'm gonna have to come back and be like, "So, guys, remember what I said this morning?" So, we'll have to see. Not even this morning. I'm saying this morning, and it's 3 o'clock in the afternoon. So we'll see. We'll see where the day takes us, and if anything new hits the docket and changes our mind, or if the lawyers get on here and make a post, and I'm like, "Oh, my bad." So, yeah. Let me know if you have questions or if you've seen new information that you want to talk about. I know that a lot of you have actually sent me some really great new pieces of information and given me a lot to think about, but that is kind of the problem. There's been some really good chunks of information that I do want to talk about and that I want to bring up in some posts. I've been trying to piece together in my mind how to talk about them and present them. But with my ADHD brain, I have too many thoughts that are competing with each other. And so doing the research, I'm kind of all over the place right now. So I don't have a coherent thought put together just yet, but that will be coming. And some of this information is stuff that I had absolutely no awareness of. So I'm doing a lot more research than I anticipated in regards to some of the stuff that you have forwarded to me. So thank you. Thank you for being here. Thank you for checking in, and we'll keep our eye on what's happening on the docket today. Thank you.